Good day, and welcome to another edition of Q&A Social Security Disability Today. Today we're actually going to have a special video presentation, Understanding Appealing Your Social Security Disability Case in Federal Court. I hope you enjoy the presentation, so let's go ahead and get started. Okay. Question was posed to me to do a special video explaining the federal court system, meaning what happens when you've exhausted your administrative remedies and now you're in federal court. Let me give you a breakdown. Typically at this particular point you've already been through the Social Security process in its entirety. It's probably been about a year, year and a half from when you act, or even 2 years or longer from the time you filed your original application. You've been denied once, maybe twice, depending on what state you're in. You've gone before an administrative law judge and you haven't been successful there. You've appealed it to the Appeals Council in Falls Church, Virginia, and you haven't been successful there. So now at that particular point, whether you're on your own or if you have a representative, you've now been advised that your next avenue is to file a civil action in federal court. In other words, what you're doing is you're suing the Social Security Administration. What I try to tell people whenever they find themselves at this point is a couple of things they need to be aware of. One, when you're suing the Commissioner of the Social Security Administration, what you're basically doing is you're trying to say that there was an error of law, meaning the way the judge applied the situation, they mishandled a particular area of law. This is where a lot of people get confused. You're not appealing the case to the United States District Court and trying to get them to make an independent determination that you're disabled. That's not what's going down here. Courts typically are going to defer to the persons who are in the best position to evaluate that medical evidence, and that's your Social Security judges. However, when you're here at this level, you're basically saying that somewhere along the line, somebody did not apply the standard by which you should be found disabled properly. Now, here's another thing you have to be aware. It's not based on what you think it is, meaning you don't appeal to federal court and say, I'm disabled, they said I'm not, and they're just wrong. Well, the reason you appeal a decision is because you disagree with it. But you have to be able to specifically identify what exactly they did wrong. And that's where it gets a little hyper complicated, because sometimes when people are doing it on their own, they're not totally sure exactly what it is. But if they believe they're disabled, they want to be able to show that they got it wrong, that the courts got it wrong, the Social Security judge got it wrong the first time around. First thing I always tell people is you can appeal a case on your own individually. You can. Court system is designed so that you can do it on your own. However, if you're not familiar with the intricacies and intricacies of what your case involved, what areas of law that maybe the person did wrong, the judge did wrong, how you need to maneuver through federal court, it is probably to your advantage to get an attorney that's admitted in that district who handles Social Security cases, because they will know what to look for and they'll be able to tell you whether or not your case is one that can prevail in federal court. Now, let's take this even a step further. Representatives who do federal court work, because I do a lot of federal court work, and I always tell people that everybody that I know who does federal court work, we have kind of the same mentality. I can't speak for everybody, but most of the ones that I know who do it typically take this mantra. They look at cases like this with a great degree of scrutiny. The reason why is because now you went before a judge, you appealed it to the Appeals Council. That Appeals Council is basically using the same standard by which the United States District Court judge is going to use. Was there an error of law? Did you screw up? Did the judge make a mistake somewhere along the lines in terms of how they made a determination that you were not disabled? So what happens? Well, you got to file a complaint. What happens? You file a complaint in federal court. It usually comes with a filing fee, and you have to notify all the appropriate parties involved that you're filing the suit after you filed it. A lot of times people don't have the money for the filing fee. So if you can't afford it, courts will sometimes let you file what we call an informal papyrus, which is a nice way of saying you're basically telling the court that you're indigent. The court then makes a determination of whether they believe you're indigent or not. If you're not indigent, then they're going to tell you got to pay that money to file for the filing fees. If you can't pay it, then unfortunately you can't file your case. Once it's filed and everybody's been served and everybody's gotten all the transcripts exchanged between each other, then the legal arguments are made. And like I said, at this particular point, you're making your legal argument that the person at the lower level, the judge, got it wrong. Now, every now and then, you'll have somebody say, well, there was some evidence that they had there, or there was some evidence that the judge didn't have. Now, here's where you got to be very careful, because Social Security, at the district court level, and usually at the appeals council, but more so at the district court level, is not going to let you supplement what the judge should have had. Meaning, if you had the ability to get the medical records, because remember, you have to prove you're disabled, not the other way around. So if you had the ability to get these medical records and you chose not to get them, or you didn't get them, you can't now get them and then go into federal court and say, hey, here they are, because the court is going to look at it and say, well, wait a minute, why didn't you get them? Do you have a good reason for not getting them? Did you have a good reason for not providing them? Why didn't you make a point to make sure the judge had this at that level? Because the court is not going to sit here and say, oh, now that we got this evidence, we're going to change our mind, unless you can demonstrate that either it's new, meaning that this is evidence that may have came up after the fact, it's material, it's something that specifically relates to your condition, and you got a good reason why you didn't provide it. So like, for instance, let's say you went to your doctor and your doctor ordered you for a very detailed MRI, and so you told the court that you have an MRI scheduled because the doctor recognized you have a bad back problem. So your appointment is scheduled for like a month from now. So the judge renders a decision before the month happens. You go to the MRI, and the MRI reveals that your back is really jacked up. Well, now you have something that you could say, well, it's new, it relates to my back, and the reason why that I didn't have it because they didn't have the MRI hadn't been taken yet. So that's information that you might be able to let the court consider. But if you've already had the MRI and you just haven't gotten it, and you tell the judge you need to go get it, that ain't gonna fly. So now when you're in court, you make your argument, the commissioner makes his argument on behalf, or her argument on behalf of the Commission of Social Security Administration, and the judge has to decide whose argument is correct. If you win, it goes back down to the Social Security Administration for further development again. If you lose, your next avenue is to appeal the case to the United States Courts of Appeal for the circuit that you live in. So for instance, if you live in Georgia, Alabama, Florida, that's the 11th Circuit. So you would appeal from your court to the 11th Circuit. Same standard applies that you do before. An error of law. And appealing to the 11th Circuit is it gets tougher. I always tell people that as the higher you go up in terms of appeals council to the United States District Court, United States District Court to the Circuit Court of Appeals, the more conservative the courts are. What do you mean by conservative? Well, the more likely they're going to find in favor of the government. So you really have to show that there was a clear-cut error of law. If you're not successful there, the next recourse is the Supreme Court. Now let me also pause and back up a second. With each of these levels, there are set deadlines. When you start suing in the federal court and going to appeal to the Circuit Court of Appeals, they have specific guidelines in terms of when you can appeal, when you have to have your legal arguments in, and what information and what format it needs to be in. And if you blow those deadline dates, they can kick it out. If you don't appeal in a manner that's consistent with what the court requires, meaning, well, let's say for instance, the court, and this is just a real big generic one. Let's say for instance you were going to court and the court requires you to wear a suit. Where you come to court on time, you got all your documents, but you come in flip-flop and sneakers, and they don't let you in the door. So now you're upset because you're in flip-flop, sneakers, cut-off shorts, and a t-shirt. You're ready to rock and roll, you're there on time, you prepared everything, you got all your documents, but you're not wearing the proper attire. Courts don't want to hear all that noise. They're going to be like, bye. And guess what happens? Now you've blown your opportunity because you didn't follow the strict protocols of the court. That's one of the reasons why I'm really always a big person to encourage individuals to get people who are attorneys who are familiar with the protocols of courts. Because a lot of times what happens when you represent yourself, if you're not intimately familiar with all these nuances, you may end up inadvertently messing yourself up. And here's the other thing that you need to be aware of. The staff, and I will tell you, I love the staff at all these courts. They are awesome people and they are very, very helpful. But they are not there to help you prosecute your case. They're not there to help you go through the process. You are on your own. And typically what they'll tell you is, if you're not familiar with what you need to do, you need to get an attorney, because they're not in the business of advising you on how to litigate your case. So you get denied by your Circuit Court of Appeal. You've already been denied by your District Court. You get denied by your Circuit Court of Appeals. Your next avenue is the Supreme Court. Now, hear me carefully when I say this. I mentioned this in a prior video, but I'm going to say it here loudly. You do not have a right to an automatic appeal to the Supreme Court. You have a right to appeal. They have a right to say no. Now, what does that mean? The Supreme Court has discretionary authority to accept cases. Remember, we only have one Supreme Court. They can't take every case that gets appealed to them. So I love when people say, I'm going to appeal this to the Supreme Court. I'm thinking, okay, you're going to try, because the reality is they only take about 20% of their cases a year. That might be even an exaggeration in terms of how many they actually do. So when you say, well, what do you mean by 20%? Well, that means if 100,000 cases come to them, they only take 20,000. Wrap your brain around that number. That means out of 100,000 cases, they only take 20,000. Maybe not even 20. I would probably say 2. I think the number is actually 8%. Let me take percent. It's a really low number. They don't take a lot of them. And the way you got to actually submit it to them has to be in a same type of format again. You have to literally send them to them in a very specific format. And then they review it, and then they will tell you whether or not we will accept this for a review. Very few cases get accepted, so keep that in the back of your mind. People, for those of you who are thinking about appealing to the United States Supreme Court, for those of you who are thinking about appealing to the United States District Court and suing the commissioner, because it says that in your decision from the Appeals Council that you have a right to file a civil action in the United States District Court, please, if you don't know what you're doing, please don't try to fudge your way through it, because the best way you can screw yourself is by fudging yourself way through a process that you have no knowledge of. Alright everybody, I want to thank you again. I hope that video helped you out a lot. By always, if you have any other questions about anything, feel free to contact me. Also, I want to say special thanks. I've been getting quite a few free claim evaluations from you. Heads up, I tend to respond initially if you have a representative by emailing you for clarification. I'm really particular about people who have representatives, because I'm a strong believer that your best resource is usually the person that you have already. So you might want to see if you can work it out with them first. So if you send me a free claim evaluation and you mention that you have an attorney, check your spam, because almost always I send an email back asking for clarification with regards to the nature of your relationship, meaning do you still have your representative or not, and whether you've attempted to work it out with them or not, because those things are important. As always, I appreciate it. Keep those questions coming. Have a wonderful day, and as always, this is your Q&A Social Security Disability Today.